Professor Dyzenhaus. It is 6 months since we conducted your first interview, and soon you'll be returning to Canada. When you spoke in January, you said somewhat jocularly that the prospect of leaving Cambridge and the Goodhart chair struck fear into your heart, because at that point you didn't want to leave. The experience thus far had been wonderful. I wondered if the last 6 months have lived up to your expectations.
Well, the last 6 months have indeed lived up to my expectations. Now that I have only 2 days left in Cambridge, I feel even worse about leaving. But I should also be clear that I will be very happy to return to Toronto. So at the moment I'm really torn. Don't want to leave here, happy to go back.
Could you summarize the courses you gave and any perhaps interesting research projects that you were able to undertake?
Well, I taught one course all of my own that was a half course in the undergraduate law degree. And that course was on the legitimacy of judicial review. And it attracted only 7 students plus some auditors. But the students were a really good bunch, and one of them was one of the most remarkable students I think I've encountered in all my years of teaching. So it was a real pleasure to teach that class. And the other course in which I participated was the LLM jurisprudence class seminar. And in that seminar, Trevor Allen and I taught the second term of the seminar. The first term I was taught by 2 other members of faculty.
Apropos your research, and speaking of Hobbes, you wrote a chapter in the book that you edited with Dr. Thomas Poole on Hobbes and the Law, published by CUP in 2012, and you cited Hobbes in your most recent CLJ article, which we can refer to later. You mentioned on page 1 of the Hobbes book that his ideas are becoming particularly prominent in recent years. And I wondered whether you had the opportunity to do any research on Hobbes while you were here.
I didn't really do dedicated research on Hobbes. I wrote one paper on Hobbes right at the beginning in my first couple of months, which I then gave as a lecture here in a series organized by Matt Kramer.
That was in January. I remember the seminar. I attended that.
And Hobbes is a figure I've been working on for probably 10 or 12 years, ever since I became convinced that if one wanted to find someone who at the beginning of the modern era had thought through the problem of the legal state in quite a lot of detail, that it's to Hobbes we should turn. And that goes against the orthodox view of Hobbes, because Hobbes is reputed to be a rather crude command theorist of law. All there is to law is the commands of a legally unlimited sovereign. But I think if one reads Hobbes's texts on law with some attention, one gets a much more nuanced picture of the way that the state is legally constituted in the modern era. And that's the problem that I've been working on for several years, trying to understand the authority of the legal state.
Interesting. What, to summarize, would you say has been the highlight or highlights of your time in the Goodhart chair?
Well, it's hard to say. Being in Cambridge for a year is a kind of highlight in itself. And being exposed to the law faculty in a way that I hadn't been before. I think I probably mentioned in our last interview that I had spent 2 6-month leaves in Cambridge prior to spending the year here. But getting a glimpse into the way the law faculty actually works, how examinations are conducted, that I thought was a real privilege, which I wouldn't have got as just an ordinary academic visitor.
Yes. When you return to Toronto, are there any new topics that you'll introduce to your courses that you may have developed in your time here?
Well, the seminar course in which I participated for the LLM, the part that Trevor Allen and I taught is a course that I've been teaching at various levels for many years at Toronto and elsewhere. So from that course, I don't think I would really take anything new back to Toronto. The course on the legitimacy of judicial review is a course that I taught for the first time. And I wanted to teach such a course for the first time. I wanted to do something that would be new for the students and new for me. And I'll definitely be working with the material and the ideas that I took from that course.
You've been elected to a fellowship at the Wissenschaftskolleg in Berlin for 2016-17 academic year. And I wonder if you could tell us something about this honour and what you planned for this.
Well, the Wissenschaftskolleg is a dedicated research institute, and it brings together a bunch of people from different disciplines, really very different disciplines. So I might be the only lawyer and legal theorist there, and the others might include architects, musicians, poets. And the idea there, as with other such research institutes, is if you throw a bunch of people together for a year and make them talk to each other, then they will find out things that otherwise they wouldn't have found out. So the only requirement at this research institute, as far as I know, is that you make yourself part of the community. So you go to lunch, you go to dinner occasionally, you talk to the other people, you participate in the events, and otherwise you do your own work. But somehow there's supposed to be a kind of energy created by having people from very different disciplines together for a year.
So you'll be there for the year?
Yeah, from July of next year till July of the following year.
So it'll be a little space when you'll be in Toronto first.
Yeah, I'll be in Toronto for a year, and I'm hoping during this year in Toronto to consolidate the various themes I've been working on over the last few years, and then to work those up into a book when I'm in Berlin.
Also, I saw on the Toronto Faculty of Law website that on June 3rd it was announced that the faculty had named you as University Professor, which is, to quote, one of the most prestigious and competitive designations bestowed by the University of Toronto on its faculty. I wondered if you could comment on that or tell us something about that.
Well, I don't, I confess, know much about the origins of this of this position. My guess is that because in North America, becoming a professor is not a big deal in the way that it is in the United Kingdom. So it's really just progress through the ranks, and this is something we might also have talked about, I can't remember. So you start off as an assistant professor, as long as you do the right sort of things when it comes to both research and teaching and taking some of the administrative load of your unit, you will become eventually an associate professor and then a full professor. So I think the idea of the university chair or professorship is to mark out a group of people who've achieved something academically that wouldn't be expected of the ordinary full professor.
I see.
And the way that it works, as far as I know, because it's a confidential process, is that someone has to nominate you, I presume the head of your faculty or department, and then a bunch of paper has to be collected about you, including referees' letters. And then this is the part that I do know, is that the people who are already university professors then decide on whether you are eligible to be a university professor. And the percentage is capped. So only a certain percentage of the total of professors at the University of Toronto can be university professors. So I guess the way that it works is that someone like me who works in legal theory and public law has to be presented to chemists, engineers, whoever else has made it to this supposedly august rank as someone who's worthy of joining them.
I understand. So it's not just a question of one appointment each year. There may be
No,
several.
there were, I think, 2 this year. Some years there might be 3, but I would doubt that they're ever more than that, because in a way they just have to keep renewing the number that's already there.
Yes. If we could just move now to your 2 publications, which you mentioned when I asked you if there'd been any output since January. There was a book that you cited and an article in the Cambridge Law Journal, and perhaps we can just talk about the book first. This is forthcoming and edited with Professor Malcolm Thornburn, who is actually an ex-student of yours and who is now at Queen's University in Kingston.
He's actually now a colleague of mine. So at the time we started editing this book, he was at Queen's University, but he's been a colleague of mine now in his second year at Toronto.
Oh, I see.
Yeah.
And the title, Philosophical Foundations of Constitutional Law, is intriguing, and I wonder if you could tell us something about this volume.
Oxford University Press has a series, Philosophical Foundations of ... law. So they've had property law, contract law, international law, and one of the law editors at Oxford University Press approached me a few years ago and asked whether I would edit the volume on philosophical foundations of constitutional law. And then when I agreed to do that, he sought out Malcolm Thornburn to be my co-editor. And so is it a year ago? No, so more or less a year ago, we put on a conference at the University of Toronto where most of the contributors to the volume came. And since then we've been busy giving them comments. I think we gave them 2 or 3 sets of comments on revised drafts of their papers, and finally it's all come together.
And your own chapter has the title, What is a Constitution? A Plea for Staatsrechtslehre. And I wonder if you can tell us the gist of this.
But it struck me when I was thinking of what I wanted to write about, which is, it seemed appropriate that someone write a paper in this volume about what a constitution is, since the title of the collection is Philosophical Foundations of Constitutional Law, that there's very little agreement amongst both public law theorists and philosophers of law about what a constitution is. There seems to be an agreement that every legal order has a constitution, but beyond that there's very little agreement. And that presented one difficulty, and then there's a second difficulty, and that is that a certain style of doing legal philosophy, which is a style you refer to in a later on the list of questions that you sent me, that is the legal positivist style, doesn't really engage with constitutional theory at all. So I wanted to, first of all, try to say something about what it is that every legal order has in having a constitution, and do so by creating an engagement between constitutional theory and legal philosophical theory, which often seems to be missing in the literature. And the idea of Staatsrechtslehre there, which is an idea I take from the German tradition of public law, is that the way to understand most of what legal philosophers do is as an attempt to understand the authority of the state. So going back to an idea that I mentioned when we were talking about Hobbes. So what is the authority of the legal state? And why do at least some theorists and philosophers, and I think many people, suppose that the authority of the state is in some way a legitimate authority, so that when the state makes a claim on us, it claims with right. So that's really the set of ideas that I look at in that chapter.
Which brings us then to your article in the Cambridge Law Journal, which appeared this month, Process and Substance as Aspects of the Public Law Form. And this was delivered originally in the conference Process and Substance in Public Law in September 2014. And I looked at the conference website and noticed there were a great many foreign common law speakers, and wondered whether you could say something about the significance of this topic as a subject matter for a conference.
Well, it's a very significant subject matter within the common law thought of the different jurisdictions that were represented at the conference. And in a way, it's one of the main themes of public law in common law countries. So judges usually try to confine themselves when they're engaged in judicial review to procedural issues on the basis that it's illegitimate for them to trespass into the substance of administrative decisions when public officials have been given authority by the legislature to make those decisions. But I think and have thought for a long time that the distinction between process and substance is a very difficult one to make. And in this paper, the one that appeared in the Cambridge Law Journal, I tried to show that process and substance are intrinsically connected because they're aspects of what I call the public law form. So that's the form that public policy has to take in order to become law. And that connects with the other ideas that I've just mentioned, because it seems to me that the authority of the legal state is deeply bound up with the form that policy has to take before it will be recognized as binding on those who are subject to it. So policy has to be put, or as I started saying in my more recent work, has to be converted. Policy has to be converted into a legal form, and I think that conversion process, which is a procedural matter, so it's a process, has an effect on content, and this is where I'm trying to find the link between process and substance.
So, in your paper, which started as your contribution to the conference, you summarize your conclusions on page 287, and I quote, you say that, whilst I reject some of legal positivism's key claims, I also find that there's much in the positivist account that is essential to understanding the formal structure of public law. And I found this very interesting, and I wondered how this squared with what you said in your earlier interview in question 45 in relation to Professor Forsyth, who was teaching at the University of Cape Town at that time, and I'm quoting, he was putting forward a positivist account of law and of the role of judges in a legal order, and this was an account which, so I was taught by John Dugard, and I accepted his teaching, should be rejected.
So my position is that the great contribution of legal positivism has been to draw our attention to the form of law, to the formal features of legal order and of particular laws. But where legal positivism falls short is that I don't think legal positivism really sees that when public policy takes legal form, the fact that it has to take legal form in order to be implemented as law does have an effect on the content of the law. Law is not just a transmission belt for public policy. Putting public policy into law actually changes the content of the policy. And on the other hand, critics of legal positivism have neglected, I think, form and have focused too much on substance. So I'm trying in my own work to show that actually there are insights to be that should be taken from both the positivist contribution to the way that we think about law and from the critics of legal positivism who might have focused too much on substance.
You mentioned the works of Thomas Hobbes in your CLJ paper to the effect that your formal theory of public law owes much to Hobbes. That's on page 1. And I wondered if you could summarize for us what this debt is.
The state?
you mentioned in your paper, you said that Hobbes, the works of Thomas Hobbes, to the effect that your formal theory of public law owes much to Hobbes.
Right.
I wondered if you could summarise what this means.
Hobbes set out in mostly in chapter 15 of Leviathan a list of what he called the laws of nature, and it's clear that these laws are binding on the state, or the sovereign, as he called the state, though it's not that clear how these laws are binding. And I think that the way to understand Hobbes is, as the great English political theorist Michael Oakeshott suggested, as putting forward a kind of grammar of law that any legal state has to abide by if it's going to be a legal state that is to rule through law and not by some other means. And this is a very interesting idea of natural law, because it's not the traditional Thomistic idea of natural law, where perhaps what natural law is some moral view which owes its origins ultimately to God, and with which positive law has to coincide if it is going to be law. Rather, it's an attempt to understand the structure of law, and to see in what way that structure of law is normative. And that idea is an idea which I think is then resurrected, but without any reference to Hobbes, by Lon Fuller in the 20th century, in his idea of there being 8 principles or desiderata of what he calls an internal morality of law, that even a tyrant has to observe if the tyrant wishes to govern by law and not by some other means. And I actually think that Hobbes has a better account of how this all works than Fuller, which is why in my more recent work I've not turned away from Fuller, but at least sought help from Hobbes in trying to flesh out this picture.
Very interesting. Still on your article, you frequently mention the Hart and the Fuller debates of 1958, which you also said in your first interview you and Professor Allen intended to focus on in your teaching of the Nazi legal regime. And I was reminded of this when I read Geoffrey Lewis's biography of Francis F.A. Mann, as apparently Mann inadvertently involved himself in a House of Lords case in 1976 via a Law Courtly Review article published in 1973 on the Oppenheim-Catamol case, where the legitimacy of a 1941 Nazi decree on Jews' German citizenship was at issue, and Mann's opinions affected the outcome, in which 2 of the law lords declared that laws like the Nazi decree of 1941 were a violation of human rights and ought not to be dignified by recognition in English courts. And while this sentiment is understandable from a moral point of view, in general cases and in practical terms, and in strongly divided societies, who would you say is ultimately to decide on such cases if no positivist notions are allowed as to what the law is?
I think I would want to take issue with about the last 5 words of your question, because I don't see why one has to throw positivistic considerations out of the window if one wants to engage in the kind of analysis that 2 of the law lords did in Oppenheim and Catamol. So even in a deeply divided society, there will be consensus about what the raw materials of law are. For example, that if the legislature does certain things, then an output is produced which we call a statute. And that statute has to be taken seriously by officials, including judges, if it seems relevant to working out what is to be done in regard to someone's conduct. But then still a bridge has to be built in working out exactly what the impact is that this piece of legal material, this artifact, will have on the particular individual. And there, I think, considerations come to bear, which have to do with what Hobbes thought of as the laws of nature, or what Fuller thought of as the principles of the internal morality of law. And for the most part, except in very unusual legal orders, one will be able to find an answer that is consistent with both recognizing this artifact as an artifact of the legal order and interpreting it in light of the principles that one thinks are appropriate for working out what impact those artifacts have on those who are subject to them. There will be limit cases where one can't actually come up with a satisfactory answer. And I don't think that in advance of examining any particular limit case, one can say what the answer should be. Now the Oppenheimer and Catamol case was probably not that problematic. Why? Because it was judges in this legal order looking at an artifact that had been produced in another legal order and refusing to let that artifact have an impact that it might ordinarily otherwise have had within their own legal order. It would be much more difficult if they were, say, looking at a statute that came from within their own legal order that was still formally speaking on the books. So to give you an example, there was a very interesting case in Canada some years ago called the Chinese head tax case. So at the turn of the 20th century and later, Chinese immigrants to Canada had to pay an exorbitant head tax on entry to Canada. So I forget the exact figures, but it amounted to about 2 years' expected wages. And eventually Chinese immigration was closed off altogether. And some years ago, a couple of very old surviving payers of this head tax, as well as some of their descendants, brought a claim in unjust enrichment against the Canadian government. And this claim was thrown out of court on the basis that there was a valid juristic reason for this taking, so there couldn't be unjust enrichment. What was the valid juristic reason? There was a statute which prescribed imposing the head tax, and that statute was valid by all the tests of the time. So the courts said there's just no reasonable basis for this action. So I think there one gets an example which is more difficult for the courts to deal with because it's a valid law within their own system. I'm not sure that the Canadian courts did the right thing in allowing that law to have force into the future in the way that they did. But in each of these cases, one has to make a very careful argument about what one thinks the impact is. And if the artifact has all the force that those who put it in place thought it should have, despite the fact that it violates the principles of legality, as I would call them, then I think there's a severe problem for that legal order.
Well, that brings us to the conclusion of this interview, and all that remains is for me to thank you very, very much indeed for these fascinating insights, which I know will be of great interest to our listeners and our readers. Thank you very much. I'm extremely grateful to you.
Well, my thanks go to you. Thank you.
Thank you.